This is a lecture from my professional responsibility class. We're going to be talking about Model Rule 7.3, which was revised in 2018, and this addresses the solicitation of clients. So let's take a look at our rule. 7.3 addresses direct contact with individual prospective clients, as opposed to advertising where you're holding yourself out to the general public as a lawyer or a law firm saying, we'd like to represent people in general. Section A gives us starts with some definitions. Solicitation or solicit denotes a communication initiated by or on behalf of a lawyer or law firm that is directed to a specific person the lawyer knows or reasonably should know needs legal services in a particular matter, and that offers to provide or reasonably can be understood as offering to provide legal services for that matter. So what are we talking about here? First of all, you're offering to represent people. It doesn't apply to merely identifying yourself as a lawyer. If you're having conversation with people and you want to say, by the way, I'm a lawyer and I practice this area, that's fine. It's when you say, and I'd like to represent you, or do you need a lawyer? Because I could do that for you. Notice also that it says that you're not allowed to do this directly or through someone else. So just like it would be a rule violation for you to go to the scene of an accident and pass out your business cards and say, I'd like to represent you if you were injured, you're not allowed to hire someone else to go to accident scenes and pass out your business card and say you should hire this lawyer. They're acting at your behest or on your behalf, so that would also count as a violation because it's just like you doing it. Section B goes to the heart of the rule, and this is the part of the rule you're most likely to see on a test like the MPRE. We start with a prohibition, and then we're going to have three categories of exceptions. A lawyer shall not solicit professional employment by live person-to-person contact when a significant motive for the lawyer's doing so is the lawyer's or law firm's pecuniary gain. By that we mean fee-paying clients. So this doesn't apply to offering to represent people pro bono or doing advocacy for civil rights for groups if you're doing it for free. And remember that this distinction between fee-paying clients and free clients or people who don't pay you was drawn by the US Supreme Court in a pair of cases in 1978. So here's our categories where it's okay to contact people, including people you don't know, or approach people kind of cold, offering to, or cold call them, offering to represent them. Lawyers, other lawyers. So we're not worried about protecting lawyers from each other in this rule. We're worried about protecting the public from lawyers. So you can call other lawyers, or if you go to networking events or bar association meetings, let's say you specialize in admiralty law, you want to give people your business card and say, if you ever need an admiralty lawyer or you want to bring an admiralty lawyer into a case, please keep me in mind. That's okay. Number two, a person who has a family, close personal or prior business or professional relationship with the lawyer or law firm. So what are we talking about here? Parents, siblings, grown children, grandparents. Actually, it doesn't really limit which family members. When you see them, or you can call them and say, by the way, I'm looking for clients, and if you need any legal work done, I'd like to do it for you. That's okay. The same is true of close personal friends. Your best friend, the person you go to the gym with a few times a week, the best man at your wedding, or your bridesmaids, your longtime roommate. You can either approach that person and offer to represent them, or if they talk to you about a legal problem they have, you can say, by the way, I'm a lawyer, I can handle that for you. Notice also it says business or professional relationships with the lawyer or the law firm. So what is that talking about? Just real quickly, your former clients, always okay to call a former client and say, hey, do you remember I represented you a couple of years ago and I was wondering if you have any other legal matters I could help you out with. That's okay. You have a prior relationship with them professionally as a client. This could also apply to vendors that your law firm uses. And let's say you hire a local business to handle all your photocopying, or a courier service, if you can contact them or approach them and say, we would love to do your legal work when you need it. Also, if you worked for an employer or company before law school, you could go to your former employer and say, I'm a lawyer now. When you need a lawyer, please keep me in mind. You have a prior business relationship with that person. Let's go back to the rule. Category 3 here was added in 2018. This is newer. A person who routinely uses for business purposes the type of legal services offered by the lawyer. So we're going to have a few examples given in the comments, but for now, think about a procurement manager at a big insurance company or a bank that outsources piecework to lawyers. And so they hire lawyers to represent policyholders when there's a claim, or to do mortgage foreclosures or things like that. You can essentially cold call an individual like that. Why they hire and fire lawyers day in and day out. They're dealing with lawyers all the time. We're not worried that you're going to take advantage of them. 7.3c is our on the other hand. So you could almost think of this as exceptions to the exceptions. A lawyer shall not solicit professional employment even when not otherwise prohibited by paragraph B, if 1, the target of the solicitation has made known to the lawyer a desire not to be solicited by the lawyer, or 2, the solicitation involves coercion, duress, or harassment. You're not allowed to harass people, right? So don't keep calling people offering to represent them. Don't threaten people even a little bit. Leave menacing messages about how if they don't hire your firm, bad things will happen to them. And if someone, notice that this applies to the people covered, those categories under the last section. So even another lawyer or a former client or a friend, if they say, please don't talk to me anymore about representing me, or please don't call me anymore, then you have to stop contacting them because they've asked you to. And if you continue to do so, it would count as a violation of this rule. 7.3d. This rule does not prohibit communications authorized by law or ordered by court or other tribunal. As we've said with a number of our other model rules, when you're operating pursuant to a court order, you almost will never be subject to discipline for doing what a court has ordered you to do. So if a court orders you or authorizes you to contact other potential parties, maybe they want to bring other parties into the case that are seem like they would have a legal interest in the matter, or the court wants to consolidate potential cases, if you're acting pursuant to a court order, you would not, it won't count as a violation, and you won't be subject to discipline. E, notwithstanding the prohibitions in this rule, a lawyer may participate in a prepaid or group legal service plan operated by an organization not owned or directed by the lawyer, that uses live person-to-person contact to enroll members or sell subscriptions for the plan from persons who are not known to need legal services in a particular matter covered by the plan. And so here we're talking about companies like Prepaid Legal Services, Inc. That's a big nationwide company. In Texas, we have Texas Legal Shield and also Texas Law Shield, which targets gun owners specifically. And these are service, almost like HMOs or subscription plan, prepaid legal services, where the customers pay an annual fee or a monthly fee, or sometimes a nonprofit or an employer or a union will cover the costs or part of the costs for their members as a benefit. And then when the customer needs a lawyer, they get a lawyer for free or at a deep discount. Here we're talking about you being a member of the pool of lawyers that they contact, and you may have to pay a fee or have some sort of relationship with the company. You can't be the owner. So this can't be like a pass-through or a proxy that you're using to solicit. But if you're just one of the lawyers that they have on their list that they refer their customers to when they need a lawyer, the company itself, they're not lawyers. So they're not bound by the solicitation rule. They can cold call strangers. They can do door-to-door sales if they want, or however they want to grow their customer list. And because you're 1 or 2 steps removed from that kind of contact, that initial contact, it won't count as a violation or solicitation on your part. There's also some comments that relate back to this section, but I'm not going to talk about them in this video. I think that's enough for now about this. I will warn you that they have on recent MPREs included 1 or maybe 2 questions about group legal service plans or prepaid legal service plans, like from that section. So don't ignore it altogether. Before we go to the comments, I wanted to remind my students that the U.S. Supreme Court has drawn a clear line or distinction between lawyer advertising and direct live solicitation of individuals for purposes of First Amendment or free speech protection. In other words, they give more free speech protection to advertising for the general public than to targeting individuals with communications. Or to put it another way, states can restrict solicitation of fee-paying clients by lawyers. For the comments, I'm going to focus only on the comments that you're likely to see turned into test questions on the MPRE or a final exam. Of course, you should read all the comments. Most of them merely restate the rule provisions or explain the policy goals, but that could help clarify your understanding of the rule or help you remember it. But let's look at comment 2. Live person-to-person contact means in-person, face-to-face, live telephone or other real-time visual or auditory person-to-person communications where the person is subject to a direct personal encounter without time for reflection. So what are we talking about? Of course, an in-person conversation that you have with someone in public or at a social event, at calling people, cold calling people who you don't know and offering to represent them. Also, Skype or FaceTime or Google video chat or Zoom. If you can make eye contact with the person and have a real-time communication, that can count as solicitation. On the other hand, look at the next paragraph. Such person-to-person contact does not include chat rooms, text messages, or other written communications that recipients may easily disregard. So essentially, we're not going to count any written communications as solicitation, whether you're sending a printed letter by regular mail, and that's a big change that they made to the rules in 2018, or even spam text messages. Lawyers can send those now because the ABA considers those advertising, and they think people are used to just deleting them or ignoring them. Comment 2 continues. There's potential for abuse when a solicitation involves direct in-person, live, telephone, or real-time electronic contact by a lawyer with someone known to need legal services. These forms of contact subject a person to the private importuning of the trained advocate in a direct interpersonal encounter. In other words, as lawyers, you have skills. We've trained you to argue and persuade, and we're afraid that you will manipulate or coerce or be overbearing with people if you're unscrupulous, and we want to protect the public from that. Now, comment 5 explains some of those kind of exceptions or safe harbor categories that we had. So let's see here. There is far less likelihood that a lawyer would engage in overreaching against a former client or a person with whom the lawyer has a close personal, family, or business relationship, or in situations in which the lawyer is motivated by considerations other than the lawyer's pecuniary gain. Again, if you're offering to represent people pro bono, we're not worried that your desperation to get some clients and fees is going to tempt you to overreach or to be overbearing. Comment 5 continues, nor is there a serious potential for overreaching when the person contacted is a lawyer, another lawyer, or is known to routinely use the type of legal services involved for business purposes. So here, again, we're talking about those 3 categories of exceptions under 7.3b. And here the ABA provides some examples of what we're talking about in 7.3b3. Examples include persons who routinely hire outside counsel to represent the entity. Again, where insurance companies and banks hire lots of lawyers to do mortgage foreclosures or represent policyholders. Entrepreneurs who regularly engage business, employment law, or intellectual property lawyers. Think of those high-tech startup companies and how the people who are running them, those kind of visionary entrepreneurs, have to deal with lawyers day in and day out. Or even established small business proprietors who routinely hire lawyers for lease or contract issues. So someone who owns big apartment buildings or commercial real estate buildings may deal with a lot of lawyers, and other people who routinely retain lawyers for business transactions or formations. In other words, if it's part of this person's job that they're dealing with, they're hiring and firing lawyers kind of day in and day out for different matters, we think that you can cold call them. You could approach them and say, I'd like to be on your list of people you call. We're not as worried that you will exploit them or be overbearing. Comment 6, on the other hand, is almost the mirror image of this. Live person-to-person contact of individuals who may be especially vulnerable to coercion or duress is ordinarily not appropriate. For example, the elderly, those whose first language is not English, or the disabled. This is almost like anti-exceptions or the opposite of safe harbor provisions. So these three categories, we're going to have heightened scrutiny or a presumption that you're violating the rule if you're soliciting these people, offering to represent them, because we think they're vulnerable and that lawyers, predatory lawyers, will kind of target them to exploit the elderly or those who have trouble communicating, or those with impairments. Almost done. Comment 8. Communications authorized by law or ordered by a court or tribunal include notice to potential members of a class in a class action litigation. So if you see a test question about 7.3D, I think it's going to be about a class action lawsuit, because it's the main example the ABA gives us, where after we have class certification, the court may authorize the lawyers to contact potential or putative members of the class to let them know, notify them that there's litigation underway and what their options are and so forth. Again, if you're acting pursuant to a court order, you're not going to be subject to discipline, or it won't count as a violation of the rule. Okay, that concludes our lecture on Model Rule 7.3, Solicitation of Clients.